I had heard it was good, but it's better than I thought. We're gonna go over the Onion's amicus brief in the Anthony Novak versus City of Parma, Ohio case in just a moment here on Lawful Masses. With me, your host, Leonard French, back here in America. Geez, somebody knows this this tone of voice, because he just comes right in to say hi the moment he hears me speaking like this, huh? You want to come up to show everybody who you are? You got it. Good boy. Yes, you good. Big hugs for being such a good boy. Novak versus City of Parma, 2022 decision of the United States Court of Appeals for the Sixth Circuit, granting qualified immunity to the City of Parma, Ohio, and its officials for prosecuting Anthony Novak over a Facebook page parodying the Parma Police Department's page. The case is now pending certiorari before the Supreme Court. It has not been granted certiorari yet, and now the case is getting a lot of attention because The Onion filed a humorous amicus curiae brief explaining how parody is supposed to work in the United States. And that's exactly what we're going to read today here on Lawful Masses. So among many posts, here's one. Due to the slow increase of a homeless population in our city, the Parma Police Department is pleased to announce that it will be introducing a new temporary law that will forbid residents of Parma from giving any homeless person food, money, or shelter in our city for 90 days. Residents caught giving the homeless population food, shelter, or water will be sentenced to a minimum of 60 days in jail. You have been warned. I think it's a great example of parody because it gives you that second of, wait a moment, is this a real post or is this a fake post? You actually have to think about it. Is it wrong to jail citizens for trying to help homeless people? And then to jail them for 60 days and then to say you have been warned? Okay, that just puts it over the top. Right? It's also a great example of Poe's law, an adage of internet culture. Without a clear indicator of the author's intent, every parody of extreme views can be mistaken for a sincere expression of the views being parodied. So try to figure out as we're going here, would you as a citizen believe that this was parody or would you have been fooled? But it's a big deal. If somebody makes fun of the government, they're criticizing the government, that's protected activity under the First Amendment. We want our citizens to be able to criticize the government and not get in trouble for it. That criticism often leads to reforms that improve the lives of your fellow Americans, and that criticism is often valid. Invalid criticism can easily be addressed. Valid criticism is valid, and who is able to tell the difference? Certainly not the government. That's not the government's job, and that's the protection of the First Amendment. The government can't come after you because you criticized it or said something it didn't like, except in some very rare circumstances where someone is literally inciting violence. We talked about that in the Brandenburg Line video. That continues to be true today. There are some limits on free speech, but it shouldn't be that Anthony Novak is unable to sue the government for retaliating against his First Amendment protected activity. That sounds wrong. Did his activity cross some line? I guess that's what the Supreme Court is being asked to review. And the Sixth Circuit case, I haven't covered that one, so I don't know exactly what the Sixth Circuit's reasoning was. It's too bad we don't have the case in front of us. A unanimous 3-judge panel of the Sixth Circuit affirmed the lower court's ruling in April 2022. The panel expressed the court's doubts about the decision to prosecute Novak, but agreed that the city and officers had qualified immunity. Unlike a previous decision in which the court had implied that probable cause could only come from Novak's speech, the Sixth Circuit wrote that it was reasonable for officers to think that Novak may have been impersonating a police officer, which, unlike parody, is not protected speech. So the Sixth Circuit granted qualified immunity to the officers because they thought it was reasonable for the officers to be confused about how to apply the law. And if you're not familiar with qualified immunity, when there's any confusion, it's not then clearly established, and therefore qualified immunity is granted, protecting the officers from Anthony Novak's civil suit. Now, Anthony Novak is asking the Supreme Court to overturn that ruling and pierce the immunity, the qualified immunity granted by the law. In the Supreme Court of the United States, on petition for writ of certiorari, The Onion's amicus brief begins. Americans can be put in jail for poking fun at the government? This was a surprise to America's finest news source and an uncomfortable learning experience for its editorial team. Indeed, Ohio police officers arrest prosecute man who made fun of them on Facebook might sound like a headline ripped from the front pages of The Onion, albeit one that's considerably less amusing because its subjects are real. So, when The Onion learned about the Sixth Circuit's ruling in this case, it became justifiably concerned. First, the obvious, The Onion's business model was threatened. This was only the latest occasion on which the absurdity of actual events managed to eclipse what The Onion staff could make up. Much more of this, and the front page of The Onion would be indistinguishable from the New York Times. Second, The Onion regularly pokes its finger in the eyes of repressive and authoritarian regimes such as the Islamic Republic of Iran, the Democratic People's Republic of North Korea, and domestic presidential administrations. So, The Onion's professional parodists were less than enthralled to be confronted with a legal ruling that fails to hold government actors accountable for jailing and prosecuting a would-be humorist simply for making fun of them. Third, the Sixth Circuit's ruling imperils an ancient form of discourse. The court's decision suggests that parodists are in the clear only if they pop the balloon in advance by warning their audience that their parody is not true. But some forms of comedy don't work unless the comedian is able to tell the joke with a straight face. Parody is the quintessential example. Parodists intentionally inhabit the rhetorical form of their target in order to exaggerate or implode it, and by doing so, demonstrate the target's illogic or absurdity. Put simply, for parody to work, it has to plausibly mimic the original. The Sixth Circuit's decision in this case would condition the First Amendment's protection for parody upon a requirement that parodists explicitly say up front that their work is nothing more than an elaborate fiction. But that would strip parody of the very thing that makes it function. The Onion cannot stand idly by in the face of a ruling that threatens to disembowel a form of rhetoric that has existed for millennia, that is particularly potent in the realm of political debate, and that purely incidentally forms the basis of The Onion's writers' paychecks. Argument. Parody functions by tricking people into thinking it is real. Tu stultus es. You are dumb. These three Latin words have been The Onion's motto and guiding light since it was founded in 1988 as America's finest news source, leading its writers towards the paper's singular purpose of pointing out that its readers are deeply gullible people. The Onion's motto is central to this brief for two important reasons. First, it's Latin, and The Onion knows that the federal judiciary is staffed entirely by total Latin dorks. They quote Catullus in the original Latin in chambers. They sweetly whisper stare decisis into their spouses' ears. They mutter cui bono under their breath while picking up after their neighbors' dogs. So The Onion knew that unless it pointed to a suitably Latin rallying cry, its brief would be operating far outside the court's vernacular. The second reason, perhaps mildly important, is that the phrase "you are dumb" captures the very heart of parody, tricking readers into believing that they're seeing a serious rendering of some specific form, a pop song lyric, a newspaper article, a police beat, and then allowing them to laugh at their own gullibility when they realize that they've fallen victim to one of the oldest tricks in the history of rhetoric. The very nature of parody is to catch the reader off guard at first glance, after which the victim recognizes that the joke is on him to the extent that it caught him unaware. It is a really old trick. The word parody stretches back to the Hellenic world. It originates the prefix para, meaning an alteration, and the suffix oda, referring to the poetry form known as an ode. One of its earliest practitioners was the 1st century BC poet Horace, whose satires would replicate the exact form known as an ode, mimicking its meter, its subject matter, and even its serious tone, but tweaking it ever so slightly so that the form was able to mock its own idiocies. This is not a mere linguistic anecdote. The point is instead that without the capacity to fool someone, parody is functionally useless, deprived of the tools inscribed in its very etymology that allow it, again and again, to perform this rhetorically powerful sleight of hand. It adopts a particular form in order to critique it from within. The parody is coming from inside the house. Parody leverages the expectations that are created in readers when they see something written in a particular form. This could be anything, but for the sake of brevity, let's assume that it is a newspaper headline. maybe one written by The Onion, that begins in this familiar way. Supreme Court rules. Already one can see how this works as a parodic setup, leading readers to think that they're reading a newspaper story. With just 3 words, The Onion has mimicked the dry tone of an Associated Press news story, aping the clipped syntax and the subject matter. The Onion could go even further by putting that headline on its website, which features a masthead and Latin motto, and the design of which parodies the aesthetics of major news sites, further selling the idea that this is an actual news story. Of course, what moves this into the realm of parody is when The Onion completes the headline with the punchline, the thing that mocks the newspaper format. The Onion could do something like, Supreme Court rules, that's Supreme Court rules. The Onion could push the parody even further by writing the joke out in article format with, say, a quote from the justices and the majority opining that, while the U.S. Constitution guarantees equality of power among the executive, legislative, and judicial branches, it most definitely does not guarantee equality of coolness. And rounding off by reporting the Supreme Court's holding that the court rules, and rules totally, all worthy and touched by nobody, in perpetuity, and in accordance with Article 3 of the Constitution. The ability of the President and the Congress to keep pace with us is not only separate, but most unequal. As can be seen, the Associated Press form is followed straight through into the article. That rhetorical form sets up the reader's expectations for how the idiom will play out, expectations that are jarringly juxtaposed with the content of the article. The power of the parody arises from the dissonance into which the reader has been drawn. Here's another example. Assume that you are reading what appears to be a boring economics paper about the Irish overpopulation crisis of the 18th century, and yet, strangely enough, it seems to advocate for solving the dilemma by cooking and eating babies. That seems a bit cruel until you realize that you are in fact reading a modest proposal. To be clear, The Onion is not trying to compare itself to Jonathan Swift. Its writers are far more talented, and their output will be read long after that hack Swift's has been lost to the sands of time. Still, The Onion and its writers share with Swift the common goal of replicating a form precisely in order to critique it from within. That leverage of form, the mimicry of a particular idiom in order to heighten dissonance between form and content, is what generates parody's rhetorical power. Parody needs to mimic an original to make its point, as the court said in Campbell v. Acuff Rose Music from 1994. If parody did not deliver that advantage, then no one would use it. Everyone would simply draft straight, logical, and uninspiring legal briefs instead. I love the fourth wall breaking. I love it. Because parody mimics the real thing, it has the unique capacity to critique the real thing. Importantly, parody provides functionality and value to a writer or a social commentator that might not be possible by, say, simply stating a critique outright and avoiding all the confusion of readers mistaking it for the real deal. One of parody's most powerful capacities is rhetorical. It gives people the ability to mimic the voice of a serious authority, whether that's the dry newspeak of the Associated Press or the legalese of a court's majority opinion, and thereby kneecap the authority from within. Parodists can take apart an authoritarian's cult of personality, point out the rhetorical tricks that politicians use to mislead their constituents, and even undercut a government institution's real-world attempts at propaganda. The point of parody is to censure the vices, follies, and abuses or shortcomings of an individual or society. So think about that for a moment. If you are Anthony Novak and you're upset at the police department of the city of Parma, Ohio, and you just go on Facebook and say, "You guys are mean to homeless people, stop being mean to homeless people," does that have the same effect as posting on Facebook pretending to be the police department and then posting a scathing critique, not by directly critiquing, but by pretending that they are being mean to homeless people, so that readers can realize, wait a second, we don't want them to be this mean to homeless people. And wait, what if they're going to be so mean to homeless people that I'm not allowed to stop it and I'm going to get 60 days in jail? Wait a second, you have been warned. And then, as The Onion says, the reader should realize this is parody. They should realize they've been tricked, and they should realize what position they were so able to accept until it was pushed just a hair further. It's a very effective vehicle for criticism and exposure, satire, parody. Time and again, that's what has occurred with The Onion's news stories. In 2012, for example, The Onion proclaimed that Kim Jong-un was the sexiest man alive. China's state-run news agency republished The Onion's story as true, alongside a slideshow of the dictator himself in all his glory. The Far's Iranian news agency uncritically picked up and ran with The Onion's headline, "Gallup poll, rural whites prefer Ahmadinejad to Obama." Domestically, the number of elected leaders who are still incapable of parsing The Onion's coverage as satire is daunting, but one particular example stands out: Republican Congressman John Fleming, who believed that he needed to warn his constituents of a dangerous escalation of the pro-choice movement after reading The Onion's headline, "Planned Parenthood opens $8 billion abortion plex." The point of all this is not that it is funny when deluded figures of authority mistake satire for the actual news, even though that can be extremely funny. Rather, it's that the parody allows these figures to puncture their own sense of self-importance by falling for what any reasonable person would recognize as an absurd escalation of their own views. In the political context, the effect can be particularly pronounced. Nothing is more thoroughly democratic than to have the high and mighty lampooned and spoofed. A reasonable reader does not need a disclaimer to know that parody is parody. At bottom, parody functions by catering to a reasonable reader, one who can tell, even after being tricked at first, that the parody is not real. If most readers of parody didn't live up to this robust standard, then there would be nothing funny about the Chinese government believing that a pudgy dictator like Kim Jong-un was the sexiest man on Earth. Everyone would just agree that it was perfectly reasonable for them to be taken in by the headline. The law turns on the same reasonable person construct. The reasonable reader test gauges whether a statement can reasonably be interpreted as stating actual facts, thereby ensuring that neither the least humorous nor the most credulous audience dictates the boundaries of protected speech. They're saying we're going to use the peak of the bell curve, not the outliers. We're going to use reasonable readers who can identify parody, not people who can't, for whatever reason, identify it, and not people who identify the joke right away, either. But people who represent the majority of reasonable readers. And the reasonable reader is no dullard. He or she does not represent the lowest common denominator, but reasonable intelligence and learning. He or she can tell the difference between satire and sincerity. Nor is the reasonable person some totally humorless drudge who cannot perceive the presence of a subtle invective. Instead, the reasonable reader's perspective is more informed by an assessment of her well-considered view than by her immediate yet transitory reaction, particularly in light of the special characteristics of satire, which leverage that transitory reaction for rhetorical effect. Context matters, but even a poorly executed parody is ordinarily susceptible to the intellectual grasp of the reasonable reader. Reasonable readers do not need to be told explicitly what they have no serious trouble figuring out for themselves. And until the Sixth Circuit's decision, that is what most courts have held. Some courts have expressly held that disclaimers aren't required for parody to be protected. Campbell, for example, noted that there is no reason to require parody to state the obvious, or even the reasonably perceived. There is no requirement that the cover of a parody carry a disclaimer that it is not produced by the subject of the parody, and we ought not to find such a requirement. Other courts have held that parody published without a disclaimer is nonetheless protected speech. For example, in NYSE versus Gahary, the district court found it entirely plausible that no one in their right mind would believe that the defendant who posted obscene and vulgar messages under the persona of Richard Grasso was the real-life Richard Grasso, the CEO of the New York Stock Exchange. The court in New Times similarly rejected the notion that the absence of a disclaimer was dispositive, or disposing of the case, noting that the reasonable reader had other obvious clues that an article was parody, when it reported that a 6-year-old girl was being prosecuted for her book report on Maurice Sendak's Where the Wild Things Are, and included a photo of a small child holding a stuffed animal captioned, "Do they make handcuffs this small? Be afraid of this little girl." See also the Patrick case. No reasonable reader would have been deceived by a memorandum purportedly written by a judge that declared a certain legal newspaper contraband, announced a chambers-by-chambers search for copies of the publication, advised fellow judges and employees to conduct their amorous escapades elsewhere while the search was being conducted, and declared the judge's intent to suspend the election of his successor and remain in office indefinitely. So, as you can see, they escalated that one, and by the time you got to the end of it, you had to figure out it was absurd. In this case, by contrast, the Sixth Circuit ruled that the defendant officers could reasonably believe that some of Novak's Facebook activity was not parody, primarily because Mr. Novak deleted comments that made clear the page was fake. But the lack of an explicit disclaimer makes no difference to whether a reasonable reader would discern that this speech was parody. And if we're using this reasonable reader standard, you can kind of take this one step further. They're saying that the Parma Police Department that was tricked by this parody and didn't figure out that it was parody, that they're being unreasonable. You know, they're the dumb ones who are unreasonable. It's a backdoor insult to anyone who is intentionally not getting this for the purposes of this case. Just to be clear, this was not a close call on the facts. Mr. Novak's spoof Facebook posts advertised that the Parma Police Department was hosting a pedophile reform event in which successful participants could be removed from the sex offender registry and become honorary members of the police department after completing puzzles and quizzes, that the department had discovered an experimental technique for abortions and would be providing them to teens for free in a police van, that the department was soliciting job applicants, but that minorities were strongly encouraged not to apply, and that the department was banning city residents from feeding homeless people in an attempt to have the homeless population eventually leave our city due to starvation. True, not all humor is equally transcendent, but the quality and taste of the parody is irrelevant. The First Amendment extends protections to a parody that had no redeeming features whatsoever, and there is no real doubt that reasonable readers would have no difficulty in ascertaining that Parma's finest were not actually providing free abortions to teens in a police van, pardoning child sex offenders on the basis of their adeptness at puzzles, or intentionally starving the homeless. The absence of a disclaimer lends nothing to the analysis. Under a proper understanding of the reasonable reader test, a disclaimer not only spoils the punchline, but is redundant. The Sixth Circuit's holding stands alone among the otherwise uniform approach courts have taken, and not in a good way. It should be obvious that parodists cannot be prosecuted for telling a joke with a straight face. This is the 15th page of a convoluted legal filing intended to deconstruct the societal implications of parody, so the reader's attention is almost certainly wandering. That is understandable. So here is a paragraph of gripping legal analysis to ensure that every jurist who reads this brief is appropriately impressed by the logic of its argument and the lucidity of its prose. Bona vacantia, de bonis asportatis, writ of certiorari, de minimis, jus accrescendi, forum non conveniens, corpus juris, ad hominem tu coc, post hoc ergo propter hoc, quod est demonstratum, actus reus, scandalum magnatum, pactum reservati domini. See what happened? This brief itself went from a discussion of parody's function and the quite serious historical and legal arguments in favor of strong protections for parodic speech, to a curveball mocking the way legalese can be both impenetrably boring and belie the hollowness of a legal position. That's the setup and punchline idea again. It would not have worked quite as well if this brief had said the following: Hello there, reader. We are about to write an amicus brief about the value of parody. Buckle up, because we're going to be doing some fairly outre things, including commenting on this text's form itself. taking the latter route would have spoiled the joke and come off as more than a bit stodgy. But more importantly, it would have disarmed the power that comes with a form devouring itself. For millennia, this has been the rhythm of parody. The author convinces the readers that they're reading the real thing, then pulls the rug out from under them with the joke. The heart of this form lies in that give and take between the serious setup and the ridiculous punchline. As Mark Twain put it, "The humorous story is told gravely. The teller does his best to conceal the fact that he even dimly suspects that there is anything funny about it." Not only is the Sixth Circuit on the wrong side of Twain, but grafting onto the reasonable reader test a requirement that parodists explicitly disclaim their own pretense to reality is a disservice to the American public. It assumes that ordinary readers are less sophisticated and more humorless than they actually are. And the stakes here are significant, involving no less than one of many more or less equally important components of social and political discourse. Rhetorical hyperbole has traditionally added much to the discourse of our nation. Although parody is often offensive, it is nevertheless deserving of substantial freedom, both as entertainment and as a form of social and literary criticism. This court has traditionally been hesitant to chill speech, and the prospect of chilling parody by imprisoning its practitioners provides equal cause for concern. What may be difficult to communicate or understand when factually reported may be poignant and powerful if offered in satire, from Rogers v. Grimaldi. The last thing we need, the last thing the First Amendment will tolerate, is a law that lets public figures keep people from mocking them. The Onion intends to continue its socially valuable role, bringing the disinfectant of sunlight into the halls of power. And it would vastly prefer that sunlight not to be measured out to its writers in 15-minute increments in a prison exercise yard. Making that final point that if this is allowed to continue to its logical conclusion, then politicians would be able to outlaw parody that doesn't come with a disclaimer. And there could be punishments for not including a disclaimer with your parody, because you could be arrested, like Anthony Novak, for impersonating a public official if you parodied a public official and they didn't get it. Do you see the slippery slope argument here? I see it, and I agree with it. Anthony Novak, whether you agreed with his humor or not, didn't do anything wrong, and certainly didn't do anything that the federal government should be able to come after, or the state government in this case. I should check the footnotes. Which footnote? See Mar-a-Lago assistant manager wondering if anyone coming to collect nuclear briefcase from Lost and Found. And I look forward to, hopefully, a meaningful and reasonable ruling by the Supreme Court. I don't know. We've got kind of a weird situation with the Supreme Court where they've made some curious rulings. So it's now, we're interested, the legal community is interested in whether we are in another Lochner era type thing where the court takes a complete turn and instead of ruling consistently decides that they're going to start restricting things. Let me know what you think in the comments below. Thanks for watching. Special thanks to my top supporters in October: Eevi, Spirit Bear, Ugly Grill, Torpedan, Gutbrodj, PureMagma, Eric Tams, TechTechPotato, The Blood-Soaked Survivors, King Aries, and Kyle Siefring. You can support more Lawful Masses productions on patreon.com/ljfrench, sponsors.com/law, through YouTube memberships, and through Floatplane subscriptions. Join me for my weekly live production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week. I love you all. Bye.